Hello friends, welcome back to a new video. So friends, today in this video I am going to share with you about the information of Supreme Court regarding special leave petition, how to file it, what are the conditions to present it before the court, who can file the SLP, and what are the contents of the special leave petition, and what is the time limit to filing an SLP. So all this information will be available with you in this video, so please watch it till the end. So basically, first of all, we must know as to what is the special leave petition in India. Special leave petition, in short, we know it as SLP, has important place in the judiciary of India. It has been provided as a residual power in the hands of the Supreme Court of India to be exercised only in cases when any substantial question of law is involved or gross injustice has been done. So under Article 136 of the Constitution of India, the Supreme Court of India vests with a special power to grant special leave to appeal against any judgment or order to decree in any matter or cause passed or made by any court, tribunal in the territory of India. This is a special power which is bestowed upon the Supreme Court of India, which is the apex court of the country, to grant leave to appeal against any judgment in case any substantial constitutional question of law is involved or gross injustice has been done. Special leave petition provides the aggrieved party a special permission to be heard in apex court in appeal against any judgment or order of any court, tribunal within the territory of India. So the next main question arises as to when can a special leave petition be filed or presented in India. So in few circumstances it can be filed, like an SLP can be filed against any judgment or decree or order of any high court or tribunal of which is within the territory of India. Or SLP can be filed in cases the high court refuses to grant the certificate of fitness for appeal to the Supreme Court of India. So now let's see what is the time limit for filing it or to present the special leave petition in India. So special leave petition can be filed against any judgment of the High Court within 90 days from the date of passing of the judgment by the concerned High Court, or SLP can be filed within 60 days against the order of the High Court refusing to grant the certificate of fitness for appeal to Supreme Court. So now who can file the SLP in India? Any aggrieved party can file the SLP against the judgment or order for refusal of grant of certificate. It can be filed by the aggrieved party himself or herself or through his pleader, who is known as the advocate on record in Supreme Court, and the filing can be done only by the name of AOR. So now what are the contents of the special leave petition which is to be mentioned in it? The petition is required to state all the facts that are necessary to enable the court to determine whether the special leave petition ought to be granted or not. It is required to be signed by the advocate on record, and because normal advocate cannot approach or file any petition in Supreme Court, a special advocate on record is eligible, who normally appointed by the Supreme Court by clearing an examination, and only thereafter advocate on record can represent a pleader litigation in court, Supreme Court. So the petition should be contained the statement that the petitioner has not filed any other petition in the High Court. The SLP should not be accompanied by a certified copy of judgment appealed against and an affidavit by the petitioner verifying the facts and the same, and should also be accompanied by all the relevant documents that form of the pleading before the lower court and the high court. So this is basically this. Now we say what are the scope of the powers which is vested by the Article 136 to the Supreme Court. So in this regard, the Constitution of India vests discretionary power in the Supreme Court of India. The Supreme Court may in its discretion be able to grant special leave to appeal from any judgment or decree or order in any matter or cause made or passed by any court or tribunal within the territory of India. So the Supreme Court of India may made or pass any order or tribunal by the court within the territory of India. The Supreme Court of India may also refuse to grant the leave to appeal because there are rarest of rare cases in which the leave normally grant by the Supreme Courts. So an aggrieved party from judgment or the decree of High Court cannot claim special leave to appeal as a right, but it is the privilege which the Supreme Court of India is vested with it, and this leave to appeal can be granted by it only. An aggrieved party can approach the Supreme Court under Article 136 in case any constitutional or legal issue exists and which can be clarified by the Supreme Court. This can be heard as a civil or criminal appeal as the case may be, and it is the discretionary power vested in the Supreme Court, and the court may in its discretion refuses to grant the leave to appeal. The aggrieved party cannot claim special leave to appeal under Article 136 as a matter of right, but it is a privilege vested in the Supreme Court of India to grant leave to appeal or not to the said aggrieved person. So this is the very short video on the point of the Supreme Court of India as to what are its functions, what are the basically contents which is to be formed in the petitions, and what are the conditions to present it, and what is the time limit to file the petition in Supreme Court against the order of the High Court or tribunal within the territory of India. So I hope you like the basic information in this regard. I have also made a separate video on the point that as to what is the process of filing a petition before the Supreme Court, link of which is being given in the description box. So friends, please share this video with others and don't forget to subscribe the channel. See you soon with other video. Thanks for watching this topic.